Okay, can you hear me now? You should be. Okay, good. All right, let's go ahead and get started. I know people are still joining, but I think it's important to go ahead and get started. And I'm going to take questions at the end so that we can get through some of these important things. And I think it may answer some of the questions that you have. So I am going to go over some of the issues we talked about earlier to put it all in context. And I will try to explain it as easily as I can, because like I said, these are all complex issues. So first, connect with us. I say this every week. We've got different ways in which we connect with people depending on the kind of information we want to provide. There is Facebook, Twitter, Instagram, YouTube videos full of lots of information that I think will be helpful, especially understanding some of the things that will come up on the H-1B end. LinkedIn, connect with me on LinkedIn, connect with Chella Long, LinkedIn. And then we have a Telegram group. So for those of you who've not joined, we will share a link. I'm sure Kara will share a link on the group message, so all of you can join the Telegram group, where we try to look through, and based on all the questions that we receive, that's one of the key mechanisms for which we come up with the topics we're going to cover and what we're going to discuss. So join us on Telegram. And like I said, our YouTube videos are really very informative. Everything from, issues that come up on RFEs to, I'm going to be posting one soon on remote employment, which may be very effective for some of the issues that are the changes that are going to take place with the H-1B regs. So please join us and subscribe to our YouTube channel. Give me a shout out, comment, and share it with your friends. That would be very helpful so we can expand our engagement. So some of the things that we're going to be covering today are, the proposed changes to the H-1B regs. Like I said, it's definitely going to be challenged, but I think that, so I'm not as worried about it, but I think it's important for you to understand what the issues are. And then we're going to talk about some decisions that you're making as to whether amend or file a new petition. I know that there's some murmurs going around as to what gets rejected and some of the problems with that, and then concerns about how it's going to affect your priority date. So what are the issues you should be looking for as you're going through this process and making this very critical condition? So we're going to talk about all of that to address the concerns raised on Telegram. So again, for those of you who have been joining me every week, welcome. For those of you who are new, welcome to our group. And we hope to be providing these very, what I hope are informative webinars where you're getting the real information. This is information that you can use, take back to your attorneys. I hope you come to us because we do a phenomenal job in the realm of business immigration and family immigration. But but even if you don't, I want to make sure that you're investing time to be with us today, and so that they're key takeaways. We've got a long presentation, so let's get started. Dol Wage Protection. So one of the things that, if you read through the regulations, and they feel like level 1 and level 2 are not really standard wages for H-1B visa holders. And it's like I said, it's challenging on so many realms, but so they're stating that the median should be level 3, and so that's why you see this increase. That's why they redid this, so that each levels change, and so it's pretty ridiculous when you think about it, because it would affect, for example, even doctors that are working in rural areas. A lot of them are on H-1Bs, and they are not getting, a lot of money because they are working for rural hospitals. And so, they would be affected. So that would directly impact level of service for this COVID epidemic. Research. A lot of research facilities don't pay high wages. And so, they're not connected with an academic institution. They're independent research facilities. And so they would be impacted. So this actually is hurting us in a time where we really need these critical services. So, as I said, they're stating that it's to protect U.S. workers, and so they're putting in the wage level is one of them, but they're putting in various restrictions to do that. And as I stated, and I predicted this, if you had been listening to our webinars every week, that a lot of this was put together in response to the federal court cases that have struck down a lot of the provisions that they're trying to impose. And so that's why I knew that these are some of the things that would come up. And just on point, they hit, if you can take the federal cases, and we have if you go to our YouTube channel, there is a webinar that's dedicated to the federal cases that have struck down some of the USCIS decisions. This is what they're doing in retaliation. Some of the key elements for proposing changes in the rules is it's twofold. Number one, an agency may not change regulatory provisions because that is within the that is what Congress is supposed to do. It's beyond the scope of their authority. A lot of what they've done is revise regulations that Congress has put forth. So that's going to be challenge number one. Challenge number two is typically an agency has to go through a notice and comment period. Well, in this particular instance, they didn't do that. And they said that this was an emergency regulatory action and it would be effective immediately. Remember, they said that even with the fee increase. And the court said, no, it's not. And it's such a substantial change, it does not, you should not be allowed to forego notice and comment. So those are some of the challenges I think that will be put forth. So this does not, so PWDs on or after October 8th, or LCAs filed on or after October 8th. So if you've got a PERM in process and you already have a PWD by the effective date, October 8th, for the prevailing wage supporting your PERM, then that's not a problem. You won't have to do it again. But for anyone that is pending, they're going to apply the new wages, which is going to throw a super wrench in the PERM processing because that was not anticipated at the time that this process took place. And so it would disenfranchise all those people who detrimentally relied on looking at the previous wage levels to determine whether, if they submit a prevailing wage, this is what we do. When we start a PERM for our clients, we will actually draft the description and so forth, and we try to look for, and we'll talk about ability to pay shortly, but we try to look for issues that are going to be brought out at the I-140 stage. We don't file a PERM just for the PERM. We file a PERM to make sure it's successful all the way through, which means looking at ability to pay. And one of the strongest ways you can prove ability to pay is if the employee is currently making that salary. So we look at what job title we're going to use, look at the wage levels, look at the job description to ensure that that job description will yield the current salary the employee is making, so there's no issues on availability to pay. That's going to be a problem going forward. So there is a reliance argument that can be made, a detrimental reliance argument on how this should be enjoined. So The prevailing wage protection rules, as I stated, it has physician wages that have now increased to $208,000, which is not going to be the case in rural areas. Organizations are going to have problems supporting that, and that's going to directly impact the way we provide pandemic services in these rural areas. And as the pandemic is, spreading in the 33 states that have reported an increase, it's going to be a problem. So they narrowed the definition of specialty occupation because there were federal court cases that talked about special occupation and said, you can't be so narrow. So they said, let's do it this way. Third-party workplace and employee-employer relationships. So these were all the things that were covered in some of the court cases. And of course, they're going to get, they're asking for more funding to do, site visits, because they love site visits. So that is how this is going to play out. So the definition of a specialty occupation. So in the court cases, the definition is that the specialty occupation has to be in a field, in a field related to the occupation. It doesn't have to be in a degree. And so as long as you look at the totality of the facts, the circumstances, and you can say, it's a field. We've been successful to overcome that because the DOL and their job descriptions are like hundreds of years old. So they don't really, they have not moved up to look at things like user interface or .NET individuals. They've got the standard descriptions that have not evolved. And they have a limited number of descriptions. So if they don't fall under the descriptions that they have, the very limited descriptions that they have for IT professions, it goes into what's called, I call it a dump file. It's called computer all other. So if it goes into computer all other, there's no degree specified for that position because it can be anything from a software engineer or somebody that's working in robotics, somebody that's working on smart appliances as a user interface. Because of its application being broad, because it's a dump file, the USCIS didn't specify a degree. That's going to raise some RFE issues down the road. So they're revising the specialty occupation, saying that it has to, if you're an electronic engineer, you should be working as an electrical engineer. We know that so many electrical engineers work in IT professions. So, and the other part that they're changing is there is a four-prong criteria that the USCIS outlines to define what's a specialty occupation. If you look back to some of our previous YouTube videos, we've been able to outline that. So they want to change the, first of all, the definition, which was typically normally required, commonly required, usually required. And these are issues that were brought up in the case where the federal, a federal judge said, hey, it's normally required. So for a hotel manager, look at the, the type of education this person had, the courses that they took. And since it's normally required, you have to look at the totality of the circumstances. You should have approved this as a specialty occupation. So they're trying to address that. And in the regs, they say, we want to get it to a must always, more frequent. So that's one of the requirements. And then with the 4 prongs, you only had to meet one of the 4 prongs. So they're changing the definition of that. So you see it's a substantial change in the regulatory definitions that Congress set forth. So that's why I said that this is going to be challenged and it will not prevail on challenge. So they redefined third-party workplace, and effectively what they're going to do is state that you only get a maximum validity of 1 year for the third-party workplace. Employer-employee relationship, they defined that to be like before they used like a 10-prong IRS definition. So now it's going to be the conventional master-servant doctrine. And they've removed contractor and instead put company. So they expand the requirements. One of the court cases stated that in response to a memo, and in response to all the RFEs and denials USCIS was issuing, because a particular, H-1B petition did not have the job order, but they could show that they had the availability of work. The regulations state that the job cannot be speculative. It can be anticipated. So you were able to overcome that by showing, hey, this contract is short, but look at all the other contracts we have. So a federal court judge said, you can't deny an H-1B petition just because it is lacking, 1 or 2 documents, as long as you can show that there is availability of work. So by narrowing the definition, they're hoping that they're able to overcome that. Like I said, all this is in direct retaliation, as we predicted, to the federal court cases. And so employee-employer relationship, it's not just enough that the employer is providing paying the employees, and it is, taking care of the benefits. They want to see how you control. And that's pretty easy, and I don't know why employers don't do this more. Even if you're doing staff augmentation, which is usually the target, there should be documentation that the petitioner is having weekly meetings telephonically with the employee and having that in some sort of formalized process. And we talked about that in the H-1B RFE YouTube video. And so if they did that, that's a way in which you can show control. Allows H-1Bs at headquarters satellite locations at third-party sites. So, like I said, they are going to be doing a lot more site visits. A couple of things to keep in mind. This goes into effect December 6th, I believe. All the H-1B changes. At that time, if you have an extension, amendment, or you're filing a new petition, all these changes are impacted. If you already have an H-1B and you're not going through the extension or so forth, then it doesn't apply. If you file before December 6th, so remember you can file an H-1B 6 months prior to your expiration, then you would not be subject to those new changes. As far as the new wages, the wages will apply are effective October 8th. So if you've already secured, whether it's for an H-1B or PERM, if you've already secured a prevailing wage document pursuant to your PERM application, and you have the certification of the prevailing wage, you don't have to worry. If it's pending, they're going to apply the new wages. If you're going to file a new H-1B effective October 8th, you would be subject to the new wages. So now let's shift gears a little bit and let's talk about the adjustment of status. So here are some of the things that we're going to talk about is considerations, issues that you should look for as you're trying to downgrade your EB2 to EB3. What we're trying to do here is kind of get rid of the murmurs and the buzz that's going around, so you can have some clear information as to what exactly you need to consider. Some of these things we've talked about before, but I feel like because of all the questions I've been seeing that it's a good time to put it all together in context. So, when you are downgrading, you can either amend your EB2 to EB3, or you can file a new petition. So you can preserve your EB2 petition. Now, the authority behind that, with the amendment, there's a 2007 memo when China advanced, EB3 advanced over EB2. And in that memo, the then USCIS officer outlined instances where the PERM could be preserved, because this was shortly after the new PERM regulations took place. So a PERM has to be filed within 180 days of its certification. If it's filed pursuant to an I-140 application, it's preserved, okay? And thereafter you can use that PERM for other things. So the memo states instances where you may need to use the PERM may occur, not must occur, not should occur, may occur. May occur, if you take it in the plain text of the language, is more, here are some illustrations, here are some examples, but they're not exhaustive, okay? And if you take that with the regulations that talks about multiple I-140 petitions, and it's even implied in the instructions. And moreover, in 2014, the Nebraska Service Center said, yes, a labor certification can have multiple applications, tells you you can do both, right? The concern a lot of people have is that this new administration, you never know how they're going to adjudicate things. And so we are at least able to point to the current USCIS policy memo that was drafted by this current administration. So this was under the USCIS director, Ken Cuccinelli, who, as you all know, I was appointed as a special immigration counsel when he was AG for the state of Virginia. The 2007 memo has just been rewritten in the US policy memo. So there is something that is current that we can point to that says we can amend. I think if you're an attorney with your SALT, you could also make your argument on a new petition, an I-140. But let's look at some of the outcomes of what the choices are. Number one, what happens if the amendment is approved? Well, you're effectively converting your EB2 into an EB3. So if it's approved, your EB2 no longer exists. That is different than a priority date. The priority date stays with you. So it doesn't impact your priority date. It just merely says that you don't have an approved EB2 classified position. If you file a new I-140, your EB2 is not affected. You would have both the EB2 and the EB3. Under an amendment, if the EB2 is denied, if the EB3 downgrade is denied, the EB2 is not effective. There have been some concerns that they go back and adjudicate the EB2, and I'm going to talk about that in a minute. If you filed as a new petition, then of course your EB2 would not be effective. Now, when you amend, remember we're filing in October for dates of filing, so they don't lock in. Dates of filing do not lock in CSPA. When you amend a petition, you don't get CSPA time, child protective time. But if you file a new petition, and this is a strategic thing, your child is getting ready to age out, this may be something you should do. Because if you file a new petition, while that I-140 is pending, It's currently taking 7 months. It's going to be longer during this period because there's going to be a lot more petitions. And if there's an RFE, that would lengthen the time period more. So that gives you more CSPA time to basically freeze the child's age. So that's a good strategic move. The other thing you have to remember is we don't know who's going to be elected in November. If it is a Biden administration, that's when all these I-140s are going to be adjudicated. If it's a Biden administration, none of this would matter. They will go back to how they've been adjudicating things previously. If it's the current Trump administration, then I still, if I had a CSPA age out, I would still, file the new petition and take that chance. You would be out fees, but other than that, it's not really a tremendous loss. If there is a retrogression for EB 3, then you could amend back to EB2, and there's a way to do that. You have to wait for the EB3 to get approved, but there is a way to do that. If you have a new I-140, you would just interfile, okay? So I wanted to start out by that. So this is, like I said, the nuances of the two. Amend is supported by the USCIS policy manual, which was created by this current administration. If it's approved, the EB2 no longer exists. If it's denied, you can, you can always refile if both the EB2 and the EB3 are denied. And I will tell you what that is. And so, and then the question of, it's been supported by ALA and a number of other message boards, but let me go through what are the biggest issues. Remember, the PERM requirements need to be met. Whether you're filing an amended, whether you're filing new, you've got to make sure all your documentation, you have to have a copy of the PERM. If you don't have it, your employer can access it by logging into his PERM account. So you get a copy. You need to show all the evidence supporting the EB2 had been met. So even if it's not going to be the requirements are needed for an EB3, you still have to think that they don't have any of the documents. And you have to make sure that the evidence aligns with the requirements in the original PERM. So the EB3, this was another question. Well, how can a master's degree be eligible for an EB3 if the PERM says a master's degree? The EB3 regulations, and I've got them down here, a professional means a qualified alien who holds at least a US bachelor's degree. That means they can have more, but at the minimum, they have to have a US bachelor's degree. What if you want to use a petition from your previous employer? Now, I have said this from the very beginning, that you should not do it through any payment to the employer. There has to be an exchange that you have the current intent. You can change your mind later, but you have the current intent to work for that employer once the green card is approved. Let me say it again. Once the green card is approved. Because permanent residence is for prospective work. That means future work. It's not for current work. But you should have documentation of that, whether it's an agreement that you all sign, whether it's emails you exchange. And you want to have that because if you are ever accused of fraud, then you can say, no, I do have an intent. Here is the documentation. So that's why it's important. And you've always got to address the ability to pay issues, which is easier when you're working for the employer because you can use pay stubs as a mechanism. When you're not working for the employer, you'd have to look at the employer's financial background to see if, you know, it would support your petition. And then how many petitions is he filing as a downgrade? So ability to pay. The petitioner is required to show that they have the ability to pay the beneficiary from the date of the certification. So let's say your PERM was certified 3 years ago. So from the date of the certification all the way up to the filing, well, it says until the petition is approved, but for practical purposes, they can't expect you to forecast, so it is only up to the date of the I-140 being filed. From the date of the certification, I'll say it again, till the date you're filing the I-140, you must prove ability to pay. And there is an administrative appeals decision in 2020 where they said that they would not consider, like, there are some, I mean, we've had very few, especially for staffing companies that have large numbers, where the USCIS has said you have to show the ability to pay, not only your application, but all the ones that are pending or have been approved from the date of your priority date, or date of labor certification, the date the labor was certified. So one of the administrative appeals 2020 decisions said, hey, in making that assessment, we will not consider any beneficiaries where the employer has paid the employee. That means if the employer has been paying the employee the proffered wage, they're not going to look at all the other employees to see if they've been paid. And I think that's why we've never gotten that type of RFE request. Often, we've only gotten it twice. In 2007, I was talking about how preserving the PERM. So this was what they said, that if the original PERM was filed timely, that means within 180 days of the labor certification determination, it preserves it. That means it's got special powers, it's preserved. And so this is the memo where they say that these filings may occur. So we have been taking that may from 2007 and doing filings for both new and amended, because may means here are some instances, but it doesn't mean these are the only instances. And so as you can see, an amended petition is filed to request a classification other than the visa classification requested in the previously filed petition. So folks have taken this very literally and think that's why they think an amended petition would have a better chance of success, because you can point to something in the US policy memo, because this memo is now memorialized in the current USCIS policy memo. Now, a lot of people have asked me questions. Well, what happens if my EB2, EB3 downgrade is denied? Does that mean I lose my priority date? Well, the regulation states that you are entitled to your priority date for any subsequent classification, and it's vested with you. And you will be afforded the earliest of the priority date available. Now, the service can't transfer your wife's priority date to yours. However, the derivative is entitled to the priority date of her, is entitled to their principals. That means if you file your adjustment, your spouse and dependents can piggyback along that, but you can't use your I-140 petition and your spouse's priority date. Now, the applicant, when you are filing any new petition, you can request the service. You have to make the request in writing. So that's why I said it's really important that your lawyer knows what they're doing. They're not going to assume that you want the earlier priority date. And a lot of times we've seen it, even when we request it in writing, they make a mistake. And so you have to show the priority date, and you have to prove that the employee is currently still eligible for the position. Okay, this is when the priority dates will not be maintained. This is the only instance where they can take your priority date from you. So when you are doing a new filing, and I think it's either whether you amend or new petition. I know a lot of people say that a new petition gets greater scrutiny, but I believe that they would do it for both, that they will make sure that there's been no fraud or misrepresentation of material fact, that the revocation of the approved labor certification was requested by the Department of Labor, that USCIS or Department of State invalidated it, or the USCIS states that there was a material error. What does that mean? So I looked at all the cases where this has taken place, and fraud or misrepresentation is where it was clear that there's no bona fide job offer. And so a lot of those instances, there was some misinformation that was placed on the forms, like experience and background. And so if your underlying perm was defective, yes, there's a risk. But if it was not defective, there's no risk. But you have to look for things like inconsistencies. Like, for example, we see this all the time, where on the perm form, you have to list your experience and education. But instead of using the letters that you outlined in the perm, you get a letter from a third-party individual that's not an employer listed. So that's going to raise a flag. If you say that if the perm states you have to have 3 years of Java experience, if you have an experience letter that does not say you have 3 years of Java experience, that's going to be a problem. So they will look at these things, because remember, a lot of these I-140s were approved a long time ago, and there has been this change even through the Obama era, but that the I-140s experience letters be more specific than they were previously. So if the underlying petition is defective, there's a problem because it may be deemed fraud, or inconsistencies of record. So like, for example, in this particular instance, the record did not establish that the individual had the 5 years of full-time experience on the labor certification. And it was interesting because the director of the DOL revoked the H-1B, but the court found, the AAO found, they didn't think that it rose to the level of fraud and misrepresentation. So they said that they would reinstate the labor certification. So the priority date sticks. So in another instance, the PERM said, we want a master's degree, but did not use the word foreign degree equivalent. So when they refiled, they used the foreign degree equivalency. And they said because the original PERM didn't say foreign degree equivalency, then you could not use that here. So that was an inconsistency. And like I said, the letter did not outline the requirements in the PERM. 3 years of Java, but the letter just said, yes, they worked for us during, and what the duties were, but they didn't say from the time period and affirmatively say that they have 3 years of experience. When we do a PERM, we put together what your experience letter should say, and we take it directly from the PERM application so that there's no ambiguity. You want to make it as simple as you can for them, so there's no way they can question anything. Can the DOL revoke the PERM automatically? Well, they can't do it immediately. what they will do is they're supposed to send the employer a notice of intent to revoke, outline what the issues that are raised, and give the employer and employee a chance to rebut. So it can be corrected. So the idea that if a petition, if you file as an amendment or file as a new petition, that if that's denied, that will immediately mean that your existing EB2 will also be denied and you will lose your priority date, is incorrect. It can only happen in instances where your original petition was defective to begin with. If it's not defective, they cannot do that. The mere fact, in other words, that your EB3 was denied does not mean your EB2 would be denied. But that's something your attorney should be looking into. In this case, in 2020, remember the employee can only pay for certain parts of, they can't pay for the advertisement and other things and the attorney fees. That is what the employer is supposed to pay. If in reviewing your petition, they find out that there was a payment involved, then they can revoke the approved petition. And that's what happened in this particular case. Okay, this is one of the cases, but it was a case in, this case a long time ago. I thought I had the date on there. Let me see. Yeah, I think they must have, when they edited it, they took the date off. But this one was for, I'd like to say it was like in early 2000s, a long time ago. So in this instance, the PERM denial was used to file a second I-140. And they said, oh, you can only use one I-140. And they cited to the matter of Haley Balin Builders. This was just a bad decision. But it was even worse because they relied on Haley Balin Builders. And Harry Baden Builders was a case where a person not only had an approved petition, but they had already adjusted. They were already a permanent resident. And then they went overseas and stayed outside the United States for more than 1 year, abandoning their permanent resident status. And when they tried to re-enter, the Department of State said, you need to go through a new petition process like you did before. They tried to use the old labor cert and old priority date to support a new filing. And they said, no. The green card has already been issued. That's been allocated. So once that's done, that's done. Although, there was another case where, you can withdraw your permanent residence and then go through the process again. And someone did that because they had married and they wanted to withdraw their permanent residence and then go through the process because they were from a country that was not, that had, where it was always current. So they were able to do that again so they could include their new foreign national spouse. So here, it was vested with him and he didn't go through the process again. And that was the main issue, and that was the case on the AILA message boards that's being cited. And I said, and so did a lot of other attorneys, that doesn't really apply to the situation now. And then there was a question about filing multiple adjustment applications. Now, here is a teleconference with the USCIS. This was in 2017, it was a Q&A. And so they said, husband has a petition, wife has a petition. Why are you getting Why do we have to get work authorization for both? Why do we have to get fingerprints for both? Why can't you consolidate? We see some members where they're being asked to withdraw one in order to move forward with the other. And the USCIS basically replied, look, we can't do all that. We don't have the bandwidth. And a person can only adjust with one application. There is a difference in distinct term from being able to adjust. Why would you need to adjust with more than one petition, right? But that's different from being able to file multiple AOS applications. And so you can do that. You may be asked by the USCIS while they're adjudicating one. They may say, hey, you've got another one pending. Why don't you withdraw it? But there is no bar per se from filing. You can only adjust with one. Interfiling. So for those of you who are, you're filing a new or amended EB2 to EB3. Remember, if you're doing an amended, you can go through the process again, get a new PERM I-140 approved, and you can do that. I mean, it's taken 7 months for the adjudication. You can do that before they even look at your petition if you're doing amended. But regardless, if you're going to try to interfile a new an EB2 I-140, you should wait till after the I-140 is approved before you do the interfiling. And the reason is, or file a new adjustment and withdraw this if it's current. So if you interfile in the interim through a pending application, they say that in order to be successful on the interfile, it's got to achieve the anticipated outcome. And so if the underlying petition is denied, the adjustment would be denied, and then you would be left with an I-140 that was interfiled as EB2, but no supporting adjustment. So you can either wait for the EB3 downgrade I-140, either through amendment or new petition to be approved, or you can file a new I-140 and a 485 with your EB2, and at some point withdraw the other. So that is a misconception that I kept hearing about. Now, the AILA update, and I think somebody posted this on Telegram. On October 7th, AILA posted with, and they can, there's hundreds of thousands of attorneys that are part of AILA. And so when they put practice pointers together, they really look to the active members that are doing this all the time. So they pointed out you can do both amend and file new. On October 9th, AILA just put a note on that practice pointer, and they said, the authors are confident that the above guidance is accurate. That means they're doing this every day. There's some folks that, some attorneys that file EB3 and EB2 every time they get a labor certification certified, every time. But they say, however, due to anecdotal reports are, rumors or things that have been reported, but we don't know what the circumstances are. We don't know the details of mailroom rejections of the second I-140 filings. Some practitioners have marked the second filing as amendment rather than new. The reported basis for the rejection was that no new labor certification. If the practitioners elect to file a subsequent I-40 as an amendment as to obviate the risk of rejection, they should be mindful that if you amend the EB2 to EB3, the EB2 will no longer be valid once the EB3 is approved. And so you've got to go through the risks and balances. Now, some of the things that I have read there are attorneys that don't clearly mark that this is a new petition, and the department, and request the DOL, the USCIS to request the DOL for the PERM. Like I said, there are a lot of practitioners that I talked to someone the other day, and he said his attorney had him filling out the I-140. I said, that would scare me. How is it you're filling it out? How do you even know to fill it out? And so he said some other comments, which led me to believe that this attorney has not done that very often, because there's certain boxes you have to check off. And if you don't check them off, depending on how you're filing it, you will get rejected. You also have to let them know and say, pursuant to, here is the regulations, I am able to do this, that you should be able to do it. Now, I looked up, we have an AILA message board, and I looked at it just yesterday. So these are comments from just yesterday. And one of the attorneys said that they received an approval. They had filed a PERM, filed the original PERM with the EB2, and then filed a EB3 along with that, with just a copy, made sure they referenced both, because if you have a copy with you when you're filing, you can do it through premium. Filed it through premium processing, and they did not, they were both approved without issue. So, I can't tell you that one way or the other way is going to give you a clear pathway. There are risks every time you file a petition with the USCIS. You all know that. But you have to look at the totality of your circumstances and see whether the risk is worth it. You have to see, okay, is it really important to me to have that EB2 in case EB3 progresses? Or can I amend, do the safer route, and then file a new PERM application now for an EB2? You have to see, does your spouse have an EB2 that they're holding on to? So you can file now, and if the spouse's EB2 becomes current, you can leverage that to file a new adjustment and then later withdraw this one. Those are some things that do you have a child that's has CSPA issues? Or are you saying, hey, you know what? I think I'll take the risk, because I've looked at my underlying EB2 petition. It is not defective. There's no problems with that. We will be able to prove ability to pay. And so I am ready to file a new petition so I can keep my EB2 and have a new EB3. And hopefully we'll have a new president, and we'll get favorable issues. But I wanted to, because of AILA's privacy, right, I could not put the names up, but I wanted to at least show you that these are all comments from just yesterday. And so people who got approved with this administration for both EB2 and EB3, and a ton of others that said that's what we're going to do. We're going to file a new petition because we want to make sure we preserve the EB2. It's important for my client. So I thought I would make sure to show that to you, so you would know that that's the clarity, that no two attorneys are going to have the same outcome. Sometimes it's a luck of the draw. Sometimes you can submit everything and you get a USCIS that's not willing to listen. But sometimes you have an attorney that doesn't know what they're doing, and so that could be the folks that got the rejection, because typically you don't get a rejection when you're asking for a new petition. And a lot of people, there are some that when they filed for a new, they would get an RFE and the USCIS would say, hey, do you want to amend instead of filing a new petition, which also diminishes the risk. So to encapsulate everything, your priority date is protected. The underlying petition is protected unless it was defective to begin with. Unless there are inconsistencies in the PERM, unless you're not submitting all the evidence that is needed to prove that you have the education and experience of the perm, and those letters substantiate everything that the perm requires, unless there was any fraud or misrepresentation done on the perm. If this is not the case, then your underlying petition should not have a problem if whether your amendment or your new petition gets denied. Your priority date and that petition would stay valid. Now, can it happen? Yes, if your underlying petition was defective or there's willful misrepresentation, but otherwise, no. Ability to pay. There's a different way to look at ability to pay if it is your current employer. If you have been paid the prevailing wage or higher, then he has proven ability to pay no matter what it says on his tax returns. He still has to submit those. There were a couple of denials where they just submitted pay stubs, but they didn't submit tax returns. They want to see the tax returns, that's one thing, but that's not for ability to pay. They're two different requirements. If you're not working for that employer, you have to look at, check out our last week's webinar where we talked about ability to pay and how you can prove it. But you have to show pay stubs. I mean, you have to show tax returns for all the years that since the labor certification determination took place. And you can prove it either by the net income of the employer or the net current assets. Then finally, yes, you can file multiple adjustments. You just are probably going to have to withdraw one at some time because you can only adjust on one application, but that doesn't mean you cannot file multiple applications. And for interfiling, great tool to use. You want to use it once your I-140 is approved. So I think this should clarify a lot of the questions that we have. Let me know what you want me to talk about next week. If you are not part of our Cella Chats forum, please join us. Here's the link. I think Kara shared it in the chats earlier. You know, I try to at least log in and check in every day to see what questions we have. If it's close to our webinar, what I'll do is I will answer those questions on the webinar so I can reach a greater number of people at one time. And, you know, join us on, connect with us on social media. You know, I love hearing comments. I love connecting with you. So, you know, and share it with your friends. You know, the more we can get more people to get the clear information and understand what their options are, the better it is for everyone. And you can view recordings of our previous webinars on YouTube at, you know, YouTube channel Cella Law. Webinars, subscribe, share with your friends, comment. I'd love to hear from you. And like I said, we keep posting different topics, and I'm sure we'll have some resources for the H-1B coming up. If you have any questions that we are not able to answer today, email us at info@cellalaw.com, and I'll type it here. Email us at info@cellalaw.com. Okay, great. So we're going to start taking questions.
All right.
And I will have Shaker Challa kind of moderate and, you know, figure out how he's going to address this so we can get the questions answered. Go ahead, Shaker.
All right. Thank you, Lakshmi. Good afternoon, everybody. I'm Shaker Challa. A couple of things, my observations. First is, I think it'll be nice if you send your questions ahead of time, if you can, since you already get a notification about the webinar once you register. That way, you know, we would have those questions compiled and the answers to give you. If you're able to respond before the seminar, we'll be able to do that too. Second thing is to request that you know, all regular, attendees and new ones. Obviously, they won't hear today, but if you could just put your questions in the Q&A box, that would be great. And if you could put all your questions at one time, that will be great. I think if you have been attending this webinar, Lakshmi always has something to say. So she would prefer, I think, correct me if I'm wrong, Lakshmi, that you would like to first present your content and then answer all the questions.
That's correct.
So the reason I wanted to reiterate that is because I've got quite a few people who have asked questions, while she's talking, and you probably think, she's going to answer. She didn't answer my question, so you're putting the same question again. So since I'm compiling the questions, I thought that would be a good thing to, give you a feedback that, unless she says she's going to take a question, I think my understanding is she'd like to present her content and then take the questions in the end. So I appreciate all of your cooperation. Appreciate all of you joining, and thank you very much for joining these webinars. And please spread the good word around about Challa Law Offices, and just say whoever comes here, they're in good hands. Lakshmi Challa and her legal team. So here's the first question that was submitted, by email. It's from AK. That's what it says. I moved from employer A to employer B 3 months ago, and previous employer A is okay now to downgrade I-140 from EB2 to 3 and file I-485 together.
Mm-hmm.
Question, by what time I should join employer A so that there won't be any issue like ATP for getting I-140 approved? Can employer A convert the previously approved H-1B to current H-1B so can work for both A and B? By the way, A did not revoke H-1B when I left 3 months ago. And the last question is, once the EB3 EAD comes in hand, and if I use it, how difficult is it to interfile 485 using previously approved EB2 140 when EB2 date becomes current than EB3? That's a long set of questions.
Yeah, but I know exactly what, it's a common question that you're asking. So remember I said it, you've got to show that you're not required to work for your previous employer until your green card is approved. Having said that, you've got to be able to demonstrate that there is a bona fide offer of employment. So you're working for the employer is a great way to demonstrate that. And the communications that you have saying that you'll join him once you have your EAD is wonderful. There is no connection between working on the EAD and your interfiling EB2. The working on the EAD only impacts your H-1B, because if you work for an employer on an EAD other than your H-1B petitioner, then your H-1B is no longer valid. So if it is not that difficult, I would go ahead and maybe, because by the time you get to this question, it'll be 2021. And so hopefully by that time we'll have a new administration and all these regulations will be null and void. And if they are, you can go ahead and amend your H-1B to new employment. And that way you can leverage both. You have to, like I said, the only thing about interfiling, and I don't know if I would imagine that you are filing a new, did he say new petition? Or is he filing an amended petition?
Or,
did he not say?
Let me just check.
So if you're filing a new petition, then yes, you can interfile once the EB3 petition is approved.
Employer A convert the previously approved H-1B to concurrent H-1B to work together to work for both employees. I moved from employer A to B 3 months ago, and previous employer A is okay now to downgrade from EB2 to 3 and file I-485. It doesn't say whether new or.
Okay, so if you're filing, this is how I can answer your question. If you're filing a new I-140, to do the downgrade, and you have your existing EB2, then wait till the EB3 is approved, and then you can interfile. It shouldn't be a problem. Next question.
All right. Sudha Venom is asking, I have my EB2 with my employer with PD as April 2013. I am with the same employer for all 3 years. My employer is suggesting to go for I-140 amendment instead of new. Could you please suggest what is best?
Yeah, I told you, you've got to make that decision yourself. I outlined that you can do either. And, you know, your employer is probably saying amend because you can point to a current USCIS policy memo that allows for amended petitions. And since you've been with the employer for 3 years, maybe he'll be willing to file a new PERM and I-140 process for you. If he is, then you would have a new I-140 approval notice that would relate back to your previous priority date, and you can use that to interfile. If you don't want to do that, and you want to make sure that your EB2 remains, then you can try filing an amended petition. Either way, you know, it's critical everyone understands this. It depends on who is elected in November. So it's hard to say how this is going to play out with that big question mark in our head. I think either way, there is an argument to be made. I just showed you a post of someone who just recently, you know, as much as 2 days ago, or 2 days ago, got, because I looked at it yesterday, received an approval notice for EB2, new petition, EB3, without the labor cert. So, you know, it's what your risk level is and what you prefer doing.
All right, I request once again, folks, to please put your questions in the Q&A box. I've seen some people are putting in the chat room, but appreciate you putting in the Q&A. Next question is from Karthik Rajashekaran. My PD is EB2 February 2014 and is current in EB3 filing date. I'm planning to file new I-140 EB3 with 485 concurrently, not amendment, to avoid losing EB2 140. I'm hearing that USCIS is sending back applications which are filed as new due to PERM being expired. What is your advice on this to avoid being rejected with new I-140 EB3 application?
I don't know, and even Ayla does not know. That's why they said, you know, that there have been some reports. We don't know whether the ones that have been rejected were completed correctly. Usually they won't reject it from the mailroom. That's very rare. They will adjudicate it, and that's something that should require an RFE. If they didn't, you know, what they do in the mailroom is they look at are all the signatures in place? Do all the checks, are they correct? Is this the correct service center? And then they check the form for eligibility just to see if there's something wrong that's checked on the form, then they will reject it. If the form states and the cover letter and everything else states clearly what you're trying to do, even if they don't like it, it should not be rejected. It should come in form of a RFE. So is there a risk? There's a risk with everything. But, you know, it depends on how badly you want to preserve your EB2.
His follow-up question says, as I'm filing new EB3 140 along with 485 in current company, if I get full-time offer later, what should I do to avoid losing EAD AP?
Well, remember you are filing this I-140 485 because you have the current intent to join the petitioning employer. If you change your mind later, the I-140 is approved, the adjustment has been pending for 180 days. You can, with the supplement, with the I-45J, change employers. There's a portability of employment as long as it's same or similar employment.
All right. Next question is from Varun K. Is there a USCIS rule that states that an EB2 PERM can be used for EB3 I-140 downgrading applications, since there are mass rejections due to PERM being out of date? If the rule permits it, how can they reject? If rejected, can a repetition happen without paying fees again? How to react to erroneous rejections?
Well, you can, if they reject it, there's a difference between a denial and a rejection. A rejection means they don't cash the filing fees. So you just refile. A denial, the fees are lost. So those erroneous rejections, I don't know why they were rejected. So, I don't know. They're very few. And so we don't know how well the attorney who filed them did all the things you're supposed to do.
All right, here's a follow-up. How about renewals for H-1B on approval I-140 or approved I-140?
Yeah, if there was no fraud or inconsistencies in your priority date and your ability to continue to get extensions on your H-1B would not be impacted.
Okay. There's a question from an anonymous attendee. Is there any lawsuit already filed in regards to wage increase?
Yes, there are several. They're gathering, well, there's several, it may not be filed, they're gathering all the documents. American Immigration Lawyers Association is filing to challenge both. And remember, it was their filing that actually overturned the fee increase. So they're pulling all the evidence right now.
All right, Mr. Naga Kilaru, thanks for your patience. Your first question, how does USCIS process 140 amendment versus 140 new filings?
I talked about that earlier in great detail. So if you came to this late, or maybe you asked this question before I got to that section, we'll be posting this in YouTube, so you can take a look at it. But I went through all the options and variations. I even have, a PowerPoint that addresses it.
Yeah, you can, I think, look at the recording. And Naga Kilaru says, I have two EB2 140s approved from different employers in 2011 and 2018. If I plan amend EB2 to 3 with 2018 approved I-140, if it is denied, does it nullify both 2011 and 2018 I-140s?
No.
Okay. Has USCIS ever retracted filing dates after it has published?
They did that years ago. I mean, they did that twice. I think once was, I think I would like to say it's 2007, but it was a different administration. So in that instance, the Department of State made a mistake. So they said everyone is current. Some glitch happened. So everybody was filing, and then they came out, and this was in the summer. So then they came out mid-July and they said, oh, we made a mistake, we want to withdraw. Lawsuits were filed. And they said, okay, everyone can file during this month. That was a different president. In, I think it was 2017, I believe, when they did that, it was in September, Department of State didn't tally all there was no reason why there should have been a jump, right, like it is now. They didn't tally all their pending petitions. All of a sudden, out of nowhere in September, the numbers jumped. And so mid-month, they withdrew and they issued a new bulletin. And you were not allowed to refile. They wouldn't take a court challenge. So that is this administration. I mean, that was this administration. So right now, there's a reason why there's a jump in numbers because of the presidential ban. So we know that this is not a calculation, they missed a calculation. So I don't think that same thing will come up now.
All right. Next question is from Gunj Gupta. I have 140 in EB2 with previous employer. Can I downgrade with my previous employer without working with him? Is it okay to work with my previous employer once I get GC?
Yes, you just want to document it.
If I get approval of EAD after downgrade to EB3 with my previous employer, can I transfer it to my new company?
You can't transfer to your new company unless you do, either through, once the I-140 is approved and the adjustments have been pending 180 days, then you can do it. There have been instances where you can interfile with a new employer, but I would rather wait for you can't even interfile until the I-140 is approved anyway. So by the time the I-140 is approved, your adjustment would have been pending for more than 180 days. So you can port doing that. Portability of portability of green cards.
All right. Next one is Samit Challa, all the same last name as us. I have refiled LCA after the new rules. Am I at risk to get RFE?
No, because as long as you filed the LCA prior to October 8th.
All right. The next one is Radha Krishna Sripada. If it is the same guy we know, welcome to United States.
That's my cousin, I think.
With your newly wedded wife. Congratulations. This question is, would the new LCA rules affect those who wish to switch jobs?
Yes. Because even if you file an amended, well, let me take that in two steps. The LCA rule, it's just the prevailing wage. So the prevailing wage, any new LCA that's filed after October 8th is impacted. So the new wages would be in effect. The other rules regarding specialty occupation, employer-employer relationship, all of that is not effective till December. So if you file for a change of employer after October 8th, before, I think it's December 6th, Kara, if I'm wrong, put the correct date on the chat, but I think it's December 6th. Then the new wage increase would apply to you, but not all the other changes.
Okay.
And if this is my cousin, you can always call me. You don't have to do it on the chat.
All right. Next one is from Shweta Sam. If for any reason I-485 is denied, is I-140 going to be still valid and one can extend based on I-140, or I-485 denial impacts H-1B?
I'm sorry, can you say that again?
If for any reason 485 is denied, is 140 going to be still valid? And one can...
You can refile the I-140 as long as there has been no determination that it was fraud, misrepresentation, or a defective underlying approval. So what would happen is, let's say, if you're amending and the amendment and adjustment get denied, as long as they don't go back because of fraud and misrepresentation and a defective underlying petition, they won't revoke your previous EB2. If you're filing a new petition and the I-140 and adjustment get denied, as long as, again, there's no problem with your previous filing, that your I-140 stands and your priority date.
Okay. So an I-140 denial impacts H-1B? That's her follow-up.
Not if you've got another, because once there's very specifically about I-140s, as long as you've got another EB2 or another I-140, the only way it doesn't impact your status directly, it would only impact the ability to continue to get 3-year extensions on your if you've capped out on your 6 years.
Okay.
So, but if you have an underlying petition, then you'd be able to use that.
All right, next question is from Aman. Is there a problem if we drop from level 3 to level 1 to meet the minimum age requirement? Can the relevant educational qualification criteria be satisfied by doing a course here in the US? I'm a master's from India, but considered a bachelor's equivalent to the in US. Does it make a difference if I do a bachelor's or a master's course?
You're talking about for H-1B. The level is not really dictated by, and I think in one of our webinars we went through this, is how the wage level is selected. It's by the duties that you undertake and what is required for the job. So it is not so much what you have, it is what the duties mandate. Now, if you have an Indian master's degree, and you want to make sure that it is from an accredited university, and if you said that you've got a credentials evaluation and it's equivalent to a bachelor's degree, you may want to do another degree so you can qualify for EB2. But other than that, the wage is dictated by the duties.
All right, next question from an anonymous attendee. I have refiled LCA after the new rules. Am I at risk to get RFE?
Well, LCA, they won't issue an RFE. Your attorney should have just immediately filed it, because it only takes 7 days. Because unless, if the wage is higher than the new adjusted wages, then there shouldn't be a problem. If not, they can just refile. There's no RFEs per se from the DOL, although this is something new where without notice they're changing their wage structure. So it's very simple at the LCA phase, so I wouldn't worry about it.
All right, next question from an anonymous attendee. Could you please share your thoughts on November and December visa bulletin? Do you think dates will move forward? My EB2 priority date is November 2015. I have an offer from one of the top tech companies. I'm in a dilemma to join the new company or not. What if the date moves after I join the new company? Any suggestions?
Well, you can always transfer back. I don't think that, I can't predict the visa bulletin, because we know that there's going to be a number of EB3 filings, more EB3 filings this month than EB2. That's a fact. I mean, we can just make that assumption. We don't know if in these EB3 filings, how many family members are associated with the file, and how many EB2s are also going to be filed this month. So it's really hard to make the projection as to what's going to happen. The visa bulletin, the October visa bulletin, Oppenheimer said that there's going to be a steady movement. But I don't know if they did any projections in stating that. So we'll have to wait and see. The visa bulletins are usually issued the 15th of every month for the following month. But like last month, it was issued later than the 15th. So as soon as we get the visa bulletin, we will make sure to post it for everyone.
Okay. Next one is from Vijay Talapragada, the Seminole. So I hope you're watching your college football season, Mr. Vijay. The question is, hello Lakshmi, as we as a company have decided that more than 50% of our staff will continue to work forever. Therefore, most of our employees will not have an office to go. In such situations, which location will the on-site inspection happen? Also, for contractors who mostly work in our IT infrastructure, will never be required to come to our office location. Will it affect their H-1B extension?
I'd have to know if you can. What I would say to you is, if you can email us at info@cellolaw.com, I can talk to you about a couple of things. So they can't come to the house. You know, I think it's only in instances where there is a work site other than the home location that's listed where they'll do a site visit. Number two, there are things called parapletic or work sites within commuting distance. So as I was reading the new regulations today, I was thinking about ways in which employers could leverage some of these issues so that they're not at that third-party site, or what would by definition be in the third-party site. And then, you know, strategies for the employer-employer relationship. One of the things I talked about earlier was having those weekly meetings and making sure it's documented. You may have a project management software that you're using where everybody has to log in and, you know, state what progress they've made every week. But send us an email at info@chalalaw.com and we can set up a time to talk so I can tell you in greater detail and with some strategies as I went through all the regs. And you can see that it's all tabbed and highlighted. So I've got some ideas of how to overcome this.
All right. Gentlemen and ladies, boys and girls, please put your questions on the Q&A and not on the chat box. Once again, thanks for your cooperation. Next question from an anonymous attendee. If H-1B renewal extension was filed back in May 2020 and is pending, does it apply? Anything we need to check for that? I-140 is already approved.
No, I mean, it only applies to applications filed after December 6th. So its effective date, I think, is the 7th. And so, and any wage increases would be LCAs filed after the 8th of October. So a pending H-1B should not be impacted.
All right, it says, the same attendee says, did you mean the DOL new rules went into effect immediately and the DHS rule will go into effect on December 6th?
I think it's 7th, but you have to file by December 6th in order to avoid the rules. So their effective date is the 7th. Yes, and it went through immediately. This is unprecedented, doesn't usually happen. They're going to be challenged. There's so many problems with this, with these new rules. But agencies are not allowed to issue, and the reason why they didn't give anyone any notice is because they didn't want anyone to file in advance in anticipation of knowing what the new rules are. I mean, it's so sinister, it makes my stomach turn. But they're not allowed to do this unless there's an emergent need. Like, let's say there is a hurricane disaster. So during, what is the one in New Orleans, the hurricane? Was it
Katrina?
Katrina. During Katrina, agencies had to redo things and they had to issue rules because there was a hurricane disaster. And these were the agencies that were servicing the hurricane. So then it was for the betterment of the people, right? So with all these in mind, they allowed it. But you can't just say, hey, we're going to take Congress's word, we're going to change them, and then we're not going to do notice and comment. This is not going to stand.
Okay. Next question from Lipi Mohanty. Will new wage apply to H-1B renewal as well?
It'll apply to any LCA. If you have to file an LCA, any LCA after October 8th.
Okay. Rahel Ayelu, sorry for the mispronunciation. Question, for an H-1B extension, do you need a new LCA?
Yes.
Okay.
Unless the company has an LCA that they're not using. That's another thing to think about. Let's say they were starting a H-1B petition for somebody with the same level and job title as you, and then that person decided not to join and they still have that certified LCA. Well, they can, here's a tip. they can use that for any new petition and not be subject to the new wages.
Senthil Kumar asks, I work under EC model, so I would like to know under the new rule how many years they are going to approve.
I don't understand the question.
His question, I work under EC model, so I would like to know under the new rule how many years they are going to approve. That's all he asked.
You got to give me some more information on your question so I can answer it.
You can send an email to info@shalalaw.com.
Or you can probably put more details.
Yeah, with the detailed information. Next question is from Ram or Rama. I'm not very sure. It says Ram, and then it says this is Rama. Question 1, should this definitely be wage 3 level for H-1B?
No, what I meant to say was the raise, how they adjusted the raise was based on what they deem was a standard wage. But we outlined before that there is still level 1, level 2, level 3, but there's an increase in the wages based on that thought process.
Follow-up question from that person. I recently moved to new employer and PERM process did not file yet. Heard that EAD for spouses have high probability to getting for RFE and denials if PERM not filed from current employer. If my current employer does EB3 downgrade and after 6 months, if I change the job to another employer and still continue to maintain H-1B visa, how does any RFEs get addressed? Do I need to change my attorney? Also, if EB2 advances at the time, can my new employer file AOS EAD?
Okay. Question number 1, can you change employers after you file a downgrade I-485? I've answered this question before, but I'm going to say it one more time. After your I-140 is approved, and you need that because you don't do an interfiling until it's approved anyway, and the 485 is pending for 180 days, you can change employers by having the new company's employer file a I-485 J, informing the USCIS, here is my new attorney, here is my J, I'm working for somebody else now in same or similar employment. The other question you asked was whether, what was the other question? Whether the employer?
If my current employer does downgrade after 6 months, if I change the job to another employer, still continue to maintain H-1B, how does any RFEs get addressed?
Right.
Do I need to change my attorney?
I addressed that, and then what was the?
Also, if EB2 advances at the time, can my new employer file AOS EAD?
If he hasn't approved your new employer, if you've got a 9-140 with the new employer, yes. Otherwise, no. The EAD is a benefit. It is not, you can only get that benefit if you file an adjustment. You can only file an adjustment or interfile an adjustment if you have an approved I-140 for that particular employer.
His last follow-up question, after 6 months, if I change job and join another employer on EAD, how does EAD duration and renewals affect my employment continuity?
If you what?
After 6 months, if I change job and join another employer on EAD, how does EAD duration and renewals affect my employment continuity?
Well, you know, you can be on an H-1B and you can be an adjustee at the same time. I always suggest that people keep their H-1B, but if you want to change employers, you've got to wait till the I-140 is approved, I-485 pending for 180 days. And if you want to then work on your EAD, you are permitted to do that. There is, until or unless the I-140 and I-485 are denied, you can continue to get extensions on your EAD.
All right. Next question from an anonymous attendee. If the DOL new wage went into effect immediately, what is the point of accepting notice and comment for 30-day period?
Really, it's not a notice and comment as the typical notice and comment. because it's effective immediately. So, you know, anything that's effective immediately, they're not really gonna change anything through notice and comment. They just want it effective immediately so that they can start getting, you know, that they can make it effective without having to let anyone know that they're going to make the change.
Okay, next question from Prem Pathak. Can you please brief about I-944 requirements specific to kids with ITIN who don't get credit report?
Right. For kids, you know, there are a lot of documentations that they require that would not be relevant to them. We have a memo on I-944, and so if you email us at info@cellolaw.com and in the subject line put I-944 memo, it's better that we send you that because it has a list and it has the explanation, which I think would help you immensely.
Okay. Next question is from Aniket Sinker. Few questions on H-1B rules. Say I am an electrical engineer. Say I am an electrical engineer. Come on, Aniket, you must be an electrical engineer. You can't say you are an electrical engineer. Just kidding. Say I'm an electrical engineer by training and work as software engineer. I know the definition of specialty training would create trouble for me. Is it possible to do a master's, say MSCIS? And would it lead to satisfying the criteria for having specialty training?
Yes, but I would just wait and see. I don't think that this is gonna, you know, we'll know something in about a month's time. Number one, either this will be enjoined by federal court, or we'll know that we have a new president. And so either way, that would not impact anything that's filed after January 14th or whenever he's sworn in, 20th or 20th or whatever that date is. It won't be impacted. If it's enjoined, it's going to be stopped from being effective. So that's probably a good thing to do professionally anyway, but I think that this is not, their regulations are not, they're going to be judicially challenged, and the challenge will be upheld. They're defective. They talk about defective PERMs, their regulations are defective. So I don't think that they would prevail.
All right, Aniket, if you need any advice on which university you should pursue your MSCIS, let me know. I can share some experience and my thoughts. His follow-up question is, if I had my H-1B approved and is valid till say 2023, he's always saying, assuming, approved notice 797. If I travel to India using the approval notice, could the new rule cause issues while stamping, and is travel to India safe with new rules?
No, because DOS has to abide by the previously approved petition, and if your visa expired within the past 24 months, you could be eligible for Dropbox, and so there would be no interview.
All right. Let's say Suresh is asking, I have a master's in electrical engineering. He's an electrical engineering guy working in IT as software engineer. If new EB3 140 is filed using EB2 PERM, is there a risk now because of electrical engineering degree? No.
No. And the funny thing is, unfortunately, immigration is not so coordinated. So the regulations that even apply, even before these new rules that apply for H-1B specialty occupations, were not the same rules within the same agency that applied to PERM. So no, there's no worries.
Okay. Next is from an anonymous attendee. My prior employer stated that for signing 485, I have to join him since he's showing negative profits every year. Thus, my salary will be shown as prove ability to prove. Is 485J signing employer needs to show ability to pay?
Not for the J, not for, you need to show it anytime you file a new, or I would say even an amended I-140. But you don't need to file it pursuant to the green card portability, which was when the I-140 is approved and the adjustment's been pending 180 days and you're changing employers to do same or similar employment. Ability to pay, they have to, you know, of course you've got the J, but it's not like the filing of a new I-140.
All right, Shankar Ramesh is asking, is it possible to switch from employer-based green card to Mattis-based green card? If yes, how long and complicated can it be?
You can, and are you marrying a U.S. citizen or a green card holder? Because if you're marrying a U.S. citizen, of course, there's no, you don't have to worry about, you know, a quota. And if you've got an adjustment pending, there may be a way to even interfile that marriage-based petition with your pending adjustment to let them know that you have an immediately available visa number.
Okay. So there were some questions in the chat, so I'm going to look at those. So like I said, please, you know, if you have any questions, put it in the QA box and not in the chat.
And it may be that they may have asked those questions in the
Yeah,
chat
they may,
and then
yeah.
ask them again in the.
Exactly. I have eliminated those, but I think here's a question from Rahul V. So I've not encountered the name Rahul. The Shah Rukh Khan fan, if you are. Maybe you have already addressed this. New H-1B rules will be effective on which date? Is 90 days from now? I know the wage is effective immediately.
They're effective for any petitions filed on December 7th onward. So you have till December 6th to file an extension or amendment, change of employers without being impacted by the new rules.
All right, next one from Anil Kumar. I moved from employee A to B 3 months and moved. I think AK must be Anil Kumar, the first question we answered. Yeah, looks like that. All right, Ravi is asking, is anyone got response for EB2 to EB3 transfer?
Yes, and a lot of people have, and they've done it both amendment, both new, and it hasn't been a problem.
Okay, just to clarify, Anil Kumar, if you are the AK that you send the questions, it looks like the same. The email, that was the first question we answered today. So if not the one, then please send your question or send us an email. Thank you. Narendra Sandil is asking, my PD is 2012 December EB2. Do you think dates will remain current in near future? I'm still waiting for my PERM to be approved with new employer.
Not sure. Last year, some months they didn't move at all. Some months they moved by a couple of days. Last month it only moved by 1 month and several days. So that was a big bump. That was the only bump for EB2. So it's hard to tell.
All right, just update and confirmation from the team here. Effective date is December 7th, 2020 for DHS rule on H-1Bs.
Right, so you've got, yeah, and so what I was saying was you have until December 6th to file before the rule becomes effective.
Okay, and then Kiran is asking, what about the HEROES Act that has language to stop spillover from FB to EB?
Well, the HEROES Act is pretty much dead on arrival. Mitch McConnell is not doing anything with that, so.
Okay, I think that's about all the questions we have from the Q&A box and the panel and the chat room. So
if you've got any other questions that you think about after we get off today, then please email us at info@cellolaw.com. If there's any specific issues you'd like us to address on the next webinar, we'd be happy to do that. We probably will get more clarification on what's happening with the H-1B, if there's any challenges and things like that. And please join our Telegram group if you have not. I think Kara shared the link, and we'd love for you to join. I'd love to hear from you. Thank you again for attending. I hope you found it helpful.
Lakshmi, a couple of more questions are coming on the chat again. So we'll just answer these as I think we'll have a cutoff time at 2 o'clock. So Warun K, sorry for posting again. In response to another question, you have mentioned about EB 2 to 3 being a problem in recent cases. Could you please elaborate what sort of problems and any remediations recommended?
Right, I didn't say that a new petition under EB3 was a problem. I said that there are rumors that some of those petitions that were filed as new petitions for EB3 were rejected. And what I said was, we don't know, and I think that's exactly even what Ayla said, is we don't know whether the problem was with the rejection or with the way in which the petition was prepared. Because unless you do all the things you're supposed to do when you're filing a new petition where you don't have a labor cert, they're going to return it. So if the attorney didn't do that and it was rejected, and they're telling Ayla it was rejected, but they may have, and then we're seeing so many other people with approvals, it may be more of a function of either it was a fluke or the attorney didn't fill out, didn't do the what is needed for the filing.
All right, Bhavana Kala is asking, can employee pay for I-140 and its premium processing fees?
Yes.
All right. I think Kiran and Varun followed up, and I'm assuming that it is the question that Bhavana Kala has asked. That was not addressed. Please check that in A and A. I guess you were saying Q and A. And even Varun said wasn't addressed. So I presume, you're talking about Bhavana Kala's question. Can employee pay for I-140 and its premium processing fees?
Yeah, and the only thing the employer is required to pay for is the PERM and the attorney's fees for the PERM.
Okay. Ravi Wali says, thank you so much for explaining in detail about EB2 to EB3 downgrade. Though, excuse me for asking this, which one is preferred method of filing, as new or amendment?
Like I said, I look at each case differently. Now, what we do is we review the case. We look at what the underlying petition to make sure it was not defective, there were no issues that could be raised. We look at the needs of the beneficiary, and we look at all those things. Do they have, do they have a spouse that has an I-140? And we talk it through with them, and we base our determination on that. I think that you can file it either way. As a lawyer, it is my job not to listen to the USCIS, but to make an argument as to why they need to listen to me. Having said that, the amended petition does have, you can point to something in the USCIS current policy manual, so that makes it easier. But that would mean that you no longer, once that's approved, you would no longer have an EB2 petition. You'd still have the priority date, but if the categories in the visa bulletin shift, where EB2 is now more advanced than EB3, you wouldn't be able to leverage that previous EB2. You could file a new PERM and a new EB2 petition now and use that to leverage it if you want to file an amend.
All right, here's a question from Joe J. Thank you very much for your webinars and Telegram chats. These have been such a helpful resource in this current situation. Thank you, Joe, for your compliment. I have a question. I was hoping you could help me with my previous employer A just filed with EB2 I-485 AOS based on the October Bulletin filing date. My current employer B has just started the PERM process. When the PERM from the new employer is approved, and if the 485 is still pending at that time, can I interfile to replace I-140 for employer A with employer B?
When you interfile while a I-140 is pending, it causes a lot of confusion, okay? And the interfile will not be successful. So in other words, they're not really going to approve the interfile until the pending I-140 is approved. Wait till your I-140 is approved. Your I-45 will be pending for 180 days, and do the I-45J and port.
Okay.
And at that time, you can, you can leverage the interfiling to, if the I-130, if the EB3 I-140 is approved and the dates are not current, then at that time you'd be able to interfile and probably but anytime you interfile, here's the thing, your 180 days start all over again. We covered that last week. So if the I-140 is approved under EB3 and then you interfile your new I-140 EB2, let's say it's with a new employer, then your 180 days to change from that employer would start from that time.
The next question from an anonymous, when is AILA planning to file the injunction to current DOL wage rule?
They're
just gone into
together,
effect on October 8th.
Probably shortly, within the next couple of weeks. They're pulling together all the documentation, so it should be soon. There's a lot of strategy that goes into this. You want to file it in a jurisdiction where you know that the federal judge was not appointed by President Trump. So they're looking at all these aspects.
Madhu Rao, it is expired on September 20. No, I think it must be a fall. Madhu Rao, I have a I-140 approved with previous employer as dates are current for my 140. I would like to go back to previous employer, but I'm currently outside of the country. Is it possible going back to previous employer? My previous employer H-1B expired September 2020.
Right, so if you're outside the country, if you're not in the country in October, you can't benefit from the adjustment filing. So you can do consular processing right now. It's been halted until December pursuant to a presidential proclamation. But, after, if there's a new president, that proclamation will no longer move forward. And we don't know if the current administration is going to extend it or not. So the big benefit of October is to file the adjustment, but you have to be here in the United States to be able to do that.
All right. Kiran, I've already asked him. Srinivasa Reddy Omkar, I have previously approved I-140 with employer A and B, filed I-140 in the month of July. I want to downgrade. Should I wait for current I-140 approval in EB2 or amend that and file for downgrade after approval? Recently upgraded my I-140 to premium processing.
What's the priority date?
It doesn't say here. I have previously approved I-140 with employer A and B, filed in the month of July. I filed I-140 in the month of July.
Yeah, but that doesn't tell me when the priority date was. So unless you have a current priority date for October, you can't file in October. So I don't know when your priority date is. It could be you had a previous I-140 that was even approved before then, but you can only leverage an October adjustment filing if your priority date comes within the dates of filing.
Pradeep Koganti, you're saying, please address my question. I'm sorry, Pradeep, I don't have your question. I looked back and forth. I don't have it. I apologize if I missed it.
Right, and if we haven't been able to answer any questions by now, email us at info@shalala.com
Yeah.
and we'll take care of it then.
Yeah, please, stuff happens. I may have made a mistake, but I don't see your question. And Aman, I think we answered 3 of your questions, and you are saying my last 2 questions were not answered. We've answered, but if you still feel you didn't get the answer, please send us an email to info@chalalaw.com. We are here to, make sure you're completely satisfied with your answer. And so is Kiran K. Please do send, any follow-up question by email. We are coming up in a couple of minutes. We'll be closing. And one question is, do you know if the specialty occupation rule will be challenged anytime soon?
It will be. I talked about that earlier. Both of them are going to be challenged, and they're going to be successful on the challenge. So,
all right, Pradeep Koganti just buckled up. Can we interfile with spouse's EB2 I-140 once my EB2 is downgraded and I move to another employer after 6 months?
Nope.
She says no.
I talked about that earlier. You can't use your spouse can benefit from your priority date, but you cannot use your spouse's priority date for your filing.
Is this a question from Naga Kilaru? I don't think this was answered. How does USCIS process 140 amendments versus 140 new filings? Yeah,
I did. I think I talked about that at length. So if you didn't hear my earlier one, please go back and listen to this YouTube video. Once we upload it on YouTube, you can listen to this webinar, because I did go through it with PowerPoints in detail.
Okay, let's see. I think our, let's see, Ravi Wally says, please take these 2 questions. And I think we've answered some of your questions, Ravi. But if we have not, then we would, oh, there it is. Can we interfile even if dates for filing, not FA dates, get current in November VB? As my PD in EB2 is 17 days away from October VB, would I wait for November VB or go ahead with downgrade? What would be your suggestion? I love your abbreviations, guys and girls.
Okay, as I said before, if you're going to interfile, you want to wait for your I-140 to be approved before you interfile.
All right, so that was the last question. You're coming up at 2 o'clock. Your attorney needs to drink some water, take some break, so that she can go back to Telegram or emails or, sign on those petitions that are going from Chalalaw Law to USCIS. You want to make sure that she is sharp before she signs, right? So give her a break. Let her get some vitamin C, banana, whatever, orange juice, and you do the same too, all you guys out there, boys and girls, women and men, and everybody else. Thank you very much. Lakshmi, your job.
Yeah, I look forward to seeing you guys next week. Join us on Telegram. Share our webinar with your friends if you found this helpful. We look forward to connecting with you again soon. Thanks again. Have a great week.
Thank you all. Take care.